A will can be challenged if there are doubts about validity or fairness. The two main ways a person can challenge a will. The first one is if they do not feel they've been adequately provided for under the will. This is usually referred to as a family provision claim. And the other way is if the circumstances around the will are not quite right and there's suspicions that the will is not valid.
A will can be invalid for a number of reasons. It might be invalid because it has been revoked for some reason, like if you've been married or you've made a new will. It can be invalid if it was signed when you didn't have capacity to sign the will, or if there's any other doubts about the circumstances surrounding the will.
The process for challenging the validity of a will varies from state to territory, so you really need to seek legal advice depending on where you are and what the process is. Generally speaking, you should raise concerns about the will prior to a grant of probate being issued. If the probate hasn't been granted yet, then you should lodge what's usually called a caveat in the relevant state or territory, so the executor who's applied for probate, it can't be granted until this issue is dealt with. And if the grant of probate has already been issued, you will usually need to make an application to the Supreme Court of the relevant state or territory.
So a challenge to the distribution of an estate under the will be can only be made by people who are eligible persons under the relevant state or territory legislation. So usually that's people like spouses, former spouses, domestic partners, children, potentially stepchildren in some circumstances, and in some circumstances maybe grandchildren or siblings of the deceased person.
If you don't think you've been adequately provided for under a will, you will need to make an application usually to the Supreme Court of the relevant state or territory you're in, and you will have to prove to the court that you either need provision because you haven't been provided for at all, or further provision for your advancement, education and maintenance of life. And again, this is usually called a family provision claim.
A family provisions claim is someone making a claim to say that they have not been adequately provided for under the deceased person's estate. So it's contesting how the estate has been distributed, even though the will is valid.
For example, they might have received a sum of money, but it's not fair in their view. And when this happens, the court will consider a range of things. They'll look at how big the estate is, what the person making the claim's relationship was like with the deceased, and what the requirements are for their life. You know, what is their health circumstances, their age, and they'll also look at that for the person who is receiving the money under the will. If you want to avoid challenges being made to your will, the main things we recommend are first looking at your estate, your assets. Can they be restructured in any way so they do not fall part of your personal estate, because your personal estate is what passes through your will typically. The other thing to do is to ensure that your will is very clear and concise. Make sure it's giving exactly what you want to who you want. And if you are leaving somebody out, talk to them. That's an option. And if it's not an option, you can also choose to leave like a statutory declaration or similar statement explaining why you've left them out, which can be relied on after you pass away.